So now I have the pleasure of introducing you to Michael Trust. So Michael went through our boot camp many, many years ago, and he's a former HR professional and had, a really interesting, diverse career and experienced so much, and went on to become an attorney focusing on employment law, helping both clients and employees and employers. And I had the opportunity of working with Michael a bit. And I can tell you, there is not very many people who are as thorough as Michael and as creative. And so I'm really excited to have Michael share what's going on in 2026 with employment law. And then, we're going to leave plenty of time for questions so you can get all your questions answered. So whether you're, an HR professional wanting to get up to speed, or just wanting to know what's going on, and an executive potentially onboarding or getting ready to exit a company, these are questions that Michael can help answer. So Michael, with that, I'm going to turn it over to you.
Thank you, and thank you for the great introduction. So this is in PDF. Let me back this up for you. Okay, so hello everybody. It's nice to meet those of you I haven't met. We've done this a couple of times. So of course I have to do as a lawyer the obligatory. This is not exhaustive. It's not legal advice. There's no attorney-client relationship, all that good stuff. So we got that out of the way. So this is all informational. I'm going to go through this fairly quickly so that we can leave time for questions, because I think that's where really the real learning takes place. So let me go through this, and this is our agenda. So legal changes in 2025, and this means they're effective in 2026. We'll talk about some strategic HR planning for these legal changes. Again, the legal changes in 2026, and case studies and best practices, just to sort of illuminate some of these concepts. So let's go through some of these quick hit legal changes. So child labor, if you have a company that engages in child labor overseas or in the United States, obviously the United States is probably not likely, and you decide that you're going to report to the state this kind of stuff, you have to do these audits and disclose these things to the state. Hopefully none of you are in that position, because it's probably not a great position to be in. There was a law passed that limits employer-sponsored political and religious meetings. The law was designed so that employers couldn't talk about unions in a negative way when employees were trying to organize. That was really the genesis of this. And this is currently on hold as a restriction on free speech for employers. And so this law that you may have heard about is currently not in effect. For many of you, this next law probably affects you, particularly if you're on the job market and doing some consulting. So Los Angeles has had this ordinance for a couple of years, but now there's a statewide ordinance, the Freelance Worker Protection Act. And basically it talks about what contractual minimums apply, how payments apply, you can't withhold payment to people, and what the remedies are if you don't pay people. Los Angeles's ordinance is a little bit stricter, and so the rules for the city of Los Angeles are different than the state rules. I think those are the only two in effect, the state one and then the pre-existing Los Angeles one. So if you're doing any kind of consulting as a freelancer, you'll want to look this up and make sure that whoever you're contracting with is aware of these rules, and to make sure you get paid on time for the work that you do. Key case law. So this was a fairly significant case. There have been some cases that have come after it. If you're an employer and you have an arbitration agreement for your employees to arbitrate any kind of disputes in the workplace, and you include sexual harassment claims in that arbitration agreement, then the entire agreement is void, essentially. The employee can go to court on everything. And this has to do with the California law saying that sexual harassment should not be hidden from the public, which is what happens in arbitration. And then the law signed during the Biden administration, the federal law about sexual harassment, and again, not hiding it in arbitration. So if hopefully none of you are in this situation, if you're an employee and you've been sexually harassed and are being forced into arbitration, you'll want to look up this case, have your lawyer talk to the opposing counsel about this case, and try to get your case excluded from arbitration. If you're an employer, you'll want to look at your current arbitration agreements. This case, Bailey versus the San Francisco DA's office. Typically, when we look at discrimination, harassment, we're looking at severe and pervasive. In this case, the racial slur was so bad that one slur could have created a hostile work environment, which then, of course, opens up a whole plethora of other claims and damages. So you'll want to be careful about that. This next case for me is personally a really great one because this comes up pretty regularly, surprisingly. And this case was up in, I want to say in the Fresno area, and an employer had an arbitration agreement with their employees. And in that arbitration agreement, of course, the employee has to sign. And the employee alleged that she never signed this arbitration agreement, that it was forged, and that she never agreed to arbitration. And this went up on appeal, and the Court of Appeals said that if an employee challenges the signature, and this really has to do more with electronic signatures, the employer must prove that the employee actually signed the agreement. So if you think about something like DocuSign that gives you an audit trail of every step in the process of the signature, if you don't have something like that, it's going to be very hard to prove that the employee actually signed the agreement themselves. Now, for a wet signature, it's easier because you can compare another wet signature from the employee to what's on the arbitration agreement. But electronic signatures are much harder to prove because anybody could have done it. And that's the distinction the court made. And so she was able to get this case out of arbitration by proving, well, she didn't have to prove anything, by alleging that she never signed this and the employer could not prove that she did. Her allegation, by the way, was that HR signed it on her behalf and she knew nothing about it. So going forward, absolutely always, if you're an employer, audit your payroll, minimum wage and exempt thresholds. The exempt threshold changed again this year, as it does every year in the state of California. And then arbitration agreements again. This Hohenstedt case has basically said that Civil Code 1281, which required employers to pay for arbitration within 30 days, or the employee could say that the arbitration was void and they could go into court. They've now said, no, as long as it's paid in a reasonable amount of time, we're not going to make it so harsh that employers are going to be kicked into court for not paying it. But if an employer is purposely delaying, that's a different story. So the other interesting thing here in arbitration agreements is, this is a fairly new case late in the year last year, is an employee alleged that they didn't remember signing the arbitration agreement, and so they didn't feel like they were bound to it. And the court basically said, if the arbitration agreement is given to the employee in a stack of other documents, so your W-4, your DE-4, your I-9, your handbook, all this other kind of stuff, then it might not be enforceable because the employee might not have realized that they signed an arbitration agreement. And because employees are waiving such important rights in an arbitration agreement, that should now be given separately to an employee, not in a stack of paperwork. So that's just something to think about. A lot of questions have come up in the new year about this next bullet point. That in California now, infertility benefits must be provided to large group employers. So that's 100 or more employees. This includes the diagnosis, the treatment for infertility, IVF with 3 egg retrievals, unlimited embryo transfers. It's a very, very broad definition of who qualifies for this. There's fertility preservation that's non-elective is also covered. It doesn't currently apply to small group plans, although small groups may offer it if they choose to. They're not required to. Religious organizations are not bound to this, as one might expect. And I'm sorry for the spelling mistake there I just saw. Medi-Cal and CalPERS, for any of you who have benefits through CalPERS, is not subject to this law until July 1st, 2027. But otherwise, it's in effect in the private sector for large group. carriers have had a lot of questions come in the new year about this particular benefit. You'll want to continue, of course, to train supervisors for accountability and legal awareness around things like leaves and disability accommodations, payroll, meaning rest breaks, meal periods, overtime, properly taking all of those kinds of things. These kinds of things are the easiest way to get sued and the easiest way to very quickly lose in many cases. This is a big one. This actually went into effect on 10/1, but I'm including it here because it's become so prevalent and it's been in the news a lot in broad kind of ways. So California has passed a law. Other states are looking at something similar. So it's going to as usual, California is going to lead the way and other states will follow with their own versions. California has defined AI very broadly. Any AI that's used in any kind of employment decision now is subject to significant risk if there's an allegation of discrimination, harassment, pay equity, anything like that. So the other big issue here is that if you use, for example, and I'm not singling them out, if you use Workday or something like Workday, it doesn't matter that they used AI, you're responsible because you use their system. And I'm sort of picking on Workday because last year they got hit with a multi-million-dollar lawsuit because their system was screening out people 40 and older. It was using AI to figure out by looking at a resume who was 40 and older and screening people out. And so they're going to have to pay a huge penalty, or a huge judgment. Employers have argued that, well, they did that. We didn't tell them to do that. And Workday's defense was the client asked us to do that. We're not responsible, and they lost. Contrast that with a case a couple of years ago against ADP, not with AI, but similar concept about who's responsible for payroll errors, where an employee sued ADP for wage and hour violations, but didn't sue her employer. The California Supreme Court in that case held no, ADP is just a processor. They're not making decisions about pay. And so if there were wage and hour violations, ADP was not liable. With this law, California is saying the employer is always liable. The third-party vendor may also be liable, but you can't pin it on the third-party vendor. So this is really a big deal if you're using these kinds of systems. Also, starting on 1/1/27 for large employers, and then in 28 for medium, and then in 29 for small employers, the state is going to require that there be a cyber audit for your cybersecurity practices, which includes AI, but not just AI. And the question, and this has to be done, by the way, by an outside auditor, which you have to pay for. So there's some concern in the legal community about whether companies want to give the state information about their cybersecurity, like that actually might not be a good thing for cybersecurity. And so I expect there's going to be pushback on this and or some narrowing of what needs to be submitted. There, we don't know yet because the state's only put out very broad contours of what this is going to look like. But this a lot of employers are seeing this as very intrusive to their security operations, and so we'll see how that plays out. CCPA, as with the bullet above, has expanded protection for employee data. So sensitive personal information, there are now more categories that are subject to CCPA. And for those of you that work in organizations that are subject to CCPA, you already know how onerous CCPA can be. CCPA, by the way, stands for the California Consumer Privacy Act. And so many states have now enacted some version of California's CCPA as well. So I would expect over time that states will now expand to follow California's. This is a hot topic. DE&I still exists in California, regardless of the federal rollback. So unless you're a federal contractor, you still are subject to whatever DE&I protections the state of California has in place. And as an employer in California, even as a federal employer, you're going to have to walk a very fine line. Should probably talk to counsel about that so you don't irritate the current administration and have your contract subject to risk and still be able to comply with California law. We've talked about continued minimum wage increases, make sure everything is updated. Hopefully now we're at the end of January. That's all been taken care of for everybody. So this next bullet, this was written before this happened. So there's an update to this first bullet. Essentially, the National Labor Relations Board didn't have a quorum until about 2 or 3 weeks ago, and so they couldn't act on anything. And so California, in its usual wisdom, passed a law that basically said the Public Employee Relations Board can step in for the National Labor Relations Board and handle organizing issues and other issues that the National Labor Relations Board would normally handle, unfair labor practices and all of that. If you're not familiar, the Public Employee Relations Board in California handles public sector employee grievances, uh, uh, any issues that happen in the public sector. If they're appealed up, they go to the Public Employee Relations Board. So this is an agency that already existed. This was expanding their scope. The federal courts have just in the last few weeks enjoined California from enforcing this law because it interferes with the federal administration of the National Labor Relations Act, which is solely the exclusive province of the National Labor Relations Board. So this law is on hold. Interestingly, the legislature extended the COVID right of recall for industries that are affected by that for another year. So till January 1, 2027. So if any of you work in those industries or want to work in those industries, then realize that that's there. California, for this next bullet, doesn't actually have a definition for what has to be in a personnel file, surprisingly. So the legislature passed a law that said basically anything about education or training records has to be in the personnel file. So even though there's no actual definition of what needs to be in the personnel file, this has to be in the personnel file. And there are specific things that have to be on the training certificate or the roster or however you're managing this process. And so the question is, does this go retro? And there's really no good answer for it. I think most companies, if they can manage it, are going to go back and look to see if their certificates or their rosters contain the information. And if they don't, they're going to try to update it. And certainly going forward, they're going to make sure. I've been in touch for some clients with some vendors who are still scratching their head trying to figure out how to make this work. And so stay tuned on this one, but it is currently in force as of January 1st. This one is interesting, and unfortunately, I've had some recent experience with this. Workplace violence protection. Public prosecutors can now, so your city attorney, your district attorney can now prosecute these more easily if they see images or threats, even if there's no intent to actually carry out the threat, but the threat must be, as you see here, unequivocal, unconditional, immediate, and there has to be some specific prospect of execution of the threat, even if there's actually no intent, you don't believe the person's really going to do it. This also expands this broader view specifically to healthcare facilities and houses of worship for all reasons that we can all certainly understand if we watch the news. So whether the public prosecutors have the time and the resources to do this and whether they will is a different story, but the law expands this. This will probably affect a lot of people here. This is the new anti-trap law. It's effective January 1st, 2026, so it's in effect now. Importantly, it is not retroactive. So what the anti-trap law is about essentially is if an employer pays for education or training or anything like that, they can't make you repay it, but there are exceptions. If they offer it to you in a separate contract, that's fine. If the credential's not a condition of employment, that's fine. And if the credential also can be used in other companies, it's not specific to you, that's fine. The contract has to specify the repayment amount is not to exceed the actual cost, which seems logical, but I guess some employers maybe were inflating that. It cannot be accelerated. It can be prorated, though. We'll talk about that in a second. It doesn't apply to unearned money. So discretionary bonuses are not covered by this. This should be done at the outset of employment. Again, a separate contract. Like some severance agreements for under 40, employees have to be given at least 5 days to consult with an attorney and that has to be in the contract. Repayment can be prorated, but without interest. They can do it if the retention period is 2 years or less, and they can defer any repayment to the end of the retention period, because if the person ends up staying, then there's no repayment, and that's fine. But if they're saying that we want you to repay it monthly, they could say, well, at 24 months, you can repay it, and if you're still here, it's waived. It's not this does not apply if someone's fired. Well, it applies if they are fired, excuse me. But if they're fired for misconduct, it does not apply. Certain governmental loan assistance program, vocational training through the government, that kind of thing doesn't apply. Certain apprentice programs don't apply. There is a $5,000 or actual damage penalty. And for all of you in HR, you will cringe when I say this, there is class representation allowed. So somebody can bring a suit on this for all employees or some class of employees if a company's not adhering to this. And as those of you in HR know, those get very, very expensive, very, very fast. This is a big one, and hopefully none of you are in this position if you're an employee, but if you're an employer, you'll want to pay attention. If you have a wage judgment from the Department of Labor Standard Enforcement, essentially the Labor Commissioner, or a court judgment, and you don't pay that judgment, after 180 days, the employee can come back to court, ask for treble damages plus attorney's fees. It's a shall, not a may. So it's up to treble damages. So you may not get treble, but you're going to get something because it's a shall, not a may. If the employer and employee or former employee more likely enter into a payment arrangement, which is what an accord is, to satisfy the 180 days, that's fine. It stops the 180 days as long as the payments are made on time. If the employer defaults, the clock doesn't start. If it's after 180 days, they're subject to this period. End of story. So a lot of employers don't pay these judgments. And so now this is what's going to happen. The state is even more serious than it already was about making sure people are paid. So job postings. So there's been a lot of talk about job postings, and of course we know for a couple of years now it's been the law with pay ranges. The problem is that employers are posting pay ranges like $100,000 to $300,000. Well, that's not a real pay range, right? Because you have no idea what the pay range is. So you now have to post a real pay range. The statute of and pay transparency now has a statute of limitation of 3 years. You have to have this good faith estimate. And here's the kicker. All compensation has to be included. So if there's stock or stock options, RSUs, overtime, profit sharing, bonus, benefits like life insurance, holiday pay, vacation pay, cleaning. So those of you in medical, if you clean, people's scrubs, that counts. Gas allowance if you have people driving, hotel accommodations if people are traveling, and other reimbursements. So these are included in what has to be done for the job posting pay range. So the state has decided that those things are part of pay and they should be done. Obviously, with stock and stock options and RSUs, you don't know, especially if you're a startup. So you're going to have to make some kind of estimate. This is more IT, but it affects employees, so I'm including it. The data breach rules have been tightened. So now there's 30 days to notify employees. Employees, of course, under these rules are considered consumers. And if there's more than 500 or more California residents affected, this goes down to 15 days. And here's the kicker, you must notify the California Attorney General's office. However, if there's a law enforcement investigation that's active and reporting this to consumers or employees would affect that investigation, there's a carve out for law enforcement purposes so that you don't compromise the investigation. So all of us in HR, or those of you still in HR, our favorite topic, California pay data, they've now expanded what needs to be reported from 10 to 23 categories, so much more to report. It's expanded the mandatory penalties for failures to do this, and this is actually effective next January to give people time to prepare. So that's on the radar for next year. There are lots of expanded job protections now with leaves. So the victim of crime has been greatly expanded for judicial proceedings, which already existed in some cases. Excuse me. to talk about prosecutors with the post-arrest decisions, with plea agreements, with sentencing, with post-conviction release decisions, or any proceeding where the rights of the person, in this case the victim, is at issue. So the victim now has a fairly expansive definition. So it's a violent felony, a serious felony, or a felony theft or embezzlement, and or someone who suffers direct or threatened physical, psychological, or financial harm due to the commission or attempted commission of these following enumerated crimes. So vehicular manslaughter while intoxicated, felony child abuse likely to produce great bodily harm or death, sexual assault resulting in the death of a child or causes significant injury, and sexual assault. So this expands to a victim appearing in court as a witness to comply with a subpoena or any other court order, an employee serving on an inquest jury or a trial jury. So this is going to probably irritate those of you that supervise employees. For jury duty in general now, employees may use at their discretion, without question, California mandatory paid sick leave to cover their jury duty cost. So it's going to be a lot harder for people to get out of jury duty because they can't. It's going to be harder to claim financial hardship if they have sick leave on the books because they can use that. But they can't be forced to use it by the employer. Whether judges will force them to use it is a different story. We don't know. I don't know how much this affects any of you, but I included it just in case. So Cal OSHA has expanded protections for silica dust exposure. So if that's something that you work with in your organizations, you'll want to look that up. This has been in the news lately. In our current political environment, California passed a law that basically said that you have to post this new notice. I think I posted it for somebody the other day. I think it's 7 pages long about various rights. If someone's arrested by ICE, that they have the right to have an emergency contact on file that the employer will contact. If they're detained or arrested while at work or during work hours. So during work hours could be a lunch break, for example. You have to have systems in place by, sorry for the typo, March 30th, but this had to be posted by January 1st. There are significant fines for failing to comply with this. There is some talk in the legal community that the state poster that the state put out goes way beyond what the law requires and may have unintended consequences, particularly in environments where there's a union contract, because it may contradict certain notification requirements or employer responsibilities in the union contract. So there's some debate about whether you should post the state poster or whether you should make your own poster and simply post what the law requires. And that's a discussion with counsel for that. This next one is pretty interesting. As you may have seen in the news in various states, I haven't actually seen this in California, but I have seen it in other states. Some employees have been suing their employers over required harassment training, claiming that the harassment training is itself discriminatory against them, and therefore they're entitled to damages. So this law says in California that is not a cause of action in California, as long as the training is made in good faith and the training itself does not constitute unlawful discrimination. So just by speaking about people's experiences and what discrimination looks like itself is not discrimination, then there's no cause of action. You can't sue over this. And this went into effect on January 1st. So as many of you know, if you're in HR, SPHRA changed the rules, I want to say 1 or 2 years ago, for leave for a designated person who is seriously ill. This law now adds on to that paid family leave may be taken for a designated person who is seriously ill. So the employee has to identify who the designated person is. They have to attest under penalty of perjury. The blood relationship or the workers' association with the designated person is the equivalent of a family relationship to take PFL. That's a much stricter definition than what's for the SPHRA leave, the California Family Rights Act. So this one's a little bit stricter, but it has expanded in some ways to match SPHRA. This is effective on July 1, 2028, so people have time to prepare for it. For Cal Warn, most of you probably know about Warn, the federal law. California has its own law. has for many years. They've now expanded CalWarn to certain notifications about what you're going to do if you're laying people off. And so the other differences between CalWarn and federal warrant still remain. This is just an expanded notification process. This one, if you're looking for a job, might affect you, and certainly if you're in finance or accounting, will affect you. In the big beautiful bill, food came up, so there is no more tax deduction for office snacks, for employer-paid meals in cafeterias, or employer-provided meals, for example, taking a candidate out to lunch or dinner with the team, whatever. That's no longer a tax deduction. So if you offer snacks, or you have an employer-funded cafeteria or subsidized cafeteria, or you have a habit of taking people out for employer-provided meals, no more tax deduction. You can still do it, you just can't deduct it. So that's sort of the non-exhaustive list of major changes. So wage and hour audit here that I was involved in prevented, millions of dollars of fines and penalties by proactively fixing issues. And this is why managers, as I said at the top, need to be continually trained on how to handle these things. Couple of disability claims, these next two in the past year that asked for multi-million-dollar settlements. One was settled for under $10,000. It would basically less than nuisance because all the documentation was in place. The employer did everything right. And so the employee's claim just basically went nowhere. And then another seven-figure demand related to disability and some other issues like retaliation was reduced to a nuisance claim because the employer was able to show that they did everything correctly, that there was really no claim here, but in the interest of settling it, we'll make a nuisance settlement so we don't have to spend hundreds of thousands of dollars on arbitration and litigation. So this goes back to managers really, really, really documenting what's going on, working with HR if they don't know how to do it, working with HR probably anyway, making sure HR is properly trained and knows how to handle these things so that employees get what they're entitled to, and there's less chance of a claim coming, and that people are treated fairly and within the bounds of the law. The training is expensive. It takes time away, I understand, from productive work, other productive work, but it saves on the back end here. So you'll want to think about creative approaches to how to implement a lot of the things we just talked about, because there's lots of implementation processes here that have to happen. You're going to want to review contracts with your third-party vendors for AI use and how they're using it and what's configured, and are we doing paid family leave correctly, and are we doing CalWarn if we have to lay people off correctly, all of this. Streamline your processes, make them efficient, reduce risk, make it very clear and transparent about what you are doing. And then again, to the point on the last slide, differentiate your business through proactive compliance, because that culture of doing the right thing helps with retention, it helps with recruitment, and it obviously mitigates a lot of legal risk, which is very, very expensive. So if you're proactive about these things, which cost some money and so takes some time, but at the back end, it saves money and time generally, and so many different ways. I would encourage you to do that. Of course, goes without saying, and I said it on some slides, there are some things you're just going to have to talk to counsel about, because it's probably something where you're going to have to make some legal determination, and or you want to have the conversation under privilege in case there's a problem, so it's not discoverable. So external support is always valuable, whether that's an HR consultant, whether that's an HR lawyer like me, something like that, to help you make these decisions if you need it. And again, I've harped on this a couple of times now. This proactive consulting saves cost versus reactive litigation. Litigation, whether it's arbitration or traditional litigation, is very, very expensive, very, very quickly. And if it's outside of arbitration, it's often also very public. And so these things, there's no benefit to the employer for these things. So keep up with legal changes to stay compliant, particularly in California. Things change at the municipal level, at the county level, at the state level, all of the time. So stay up to date with these things. plan ahead. You know, some of these laws aren't going into effect now for till 27, 28, and in some cases 2030. So you can plan now for these things and empower your HR teams with what they need to make sure these things get done, that they're well trained, that they can communicate these things, that they can help with this culture of compliance and treating people fairly, and so that you can mitigate these risks. But if HR can't do those things, then you have a problem. So give HR what they need to help with these things. And with that, I'm going to stop sharing and we'll open it up.
All right. So no questions in the chat, but I am sure that there are questions. But as we know, I have some. So there's a couple things because I've had some conversations with executives recently who are getting job offers and onboarding with companies. One of the biggest, and everyone that I've talked to is walking in with the understanding that there could be a layoff, or the company is going through a lot of changes and fluctuations. What are some things as they're looking at the employment agreement that they need to be aware of?
So, I mean, before they even look at the employment agreement, I think I'd want to do a lot of due diligence about what are the likelihood, what do the financials look like, what's the product pipeline look
Well,
like?
so assuming they've already done that,
Yeah. Oh,
and
assuming they've
and
already done
but
that.
but
Okay.
it's really about, hey, I feel like I need to negotiate my exit
Right. I was going to say,
upon
so
entry.
right. So that's not uncommon, actually, particularly at senior levels, to negotiate an exit upon entry. And so I think I would look at what severance policies look like if they exist, and then negotiate from there. If they don't exist, then do a negotiation from the jump, so to speak, about, well, you've told me that, layoffs are possible, and in that event, I need to have some back end protection here. So in order to take this job, I'm going to need to negotiate some back end severance and possibly, well, I was going to say some COBRA payments, but if the company closes, there's no COBRA because there's nothing to COBRA. So they can negotiate a cash value of COBRA. And there's some ways that I do that that's a little bit different than the way a lot of other people do it. But and then make sure that they're covered on the back end.
Okay, great. Another question, is the pay equity change on job posting to narrow the pay range and include comp effective 1/1/27 or 1/1/26?
26.
Wow. That's I mean, it's like companies have to really calculate that. That's a huge challenge.
I don't know how
And
I don't know how they're going to enforce it, because how are they going to challenge what you valued stock at a startup that has no value yet? I mean, right? How are they
right.
going to
Or
challenge that?
not even offered, right?
Right. Or not even, well, if it's not offered, it won't be included. So, but the life insurance is probably fairly easy to calculate, right?
Okay, and
Uh,
then Bill asks, anti-trap
yes,
covers signing bonuses and relocation payments made by does anti-trap cover signing bonuses and relocation payments made by
it
employers
it
to new
it
employees?
does cover relocation. Um, Signing bonuses, depending on how the signing bonus is structured, it might or might not.
Okay, and then fertility benefits, they're pretty open-ended. Is this explicitly for employees only, or does it apply to covered dependents as well?
It applies to the whole plan. So anybody who's enrolled in the plan.
Okay. And pay equity change on job postings applicable to the posting that is reposted in 2026, but was originally posted in 2025.
If it's posted in 2026 or beyond, it applies.
Okay, whether or not it was posted in
Doesn't
2025.
matter. Yeah.
Okay, I also request severance and change of ownership in case the company is acquired.
Right.
Yeah, and that's pretty common anymore.
That's common. Yeah.
Um, so interesting considering that many companies do not post the salary range. Yes, a lot of companies are still not posting the salary range.
So this is in response to that. And then, as I mentioned, in response to these wildly broad salary ranges that don't tell anybody,
Yeah.
right?
So, Will puts regarding risks, companies will lay off employees before they vest any equity.
Right.
Is there a way to have them protect the vesting for at least the portion that they would have vested prior to the termination?
You can always ask, but what the fallback position generally is, well, this is a document that's governed by the terms of the stock or RSU agreement, and the agreement doesn't allow us to do anything else. That's sort of the default position. I have seen it negotiated where if there are other issues with the termination, not necessarily a layoff, but say other issues, discrimination, harassment, where they may say, well, we'll give you the cash value at some percentage pro rata of what might have vested in that sense, but it's most companies are, in my experience at least, are resistant to do it. And to the point of the person who asked the question, you see this a lot when someone's about to vest or close a huge sale with a huge commission, where suddenly there's a layoff or termination because the company doesn't want to pay. It's very, very common. I had so many of these last year, and I've got a couple now where it's like, come on, this person was going to vest next week. I mean, you're really laying them off now. I mean, come on. It's so obvious what's happening here, right?
Yeah, that's interesting. And then same thing with retirement. There was somebody that I spoke to a couple weeks ago. They were laid off like within 3 weeks of their retirement. And
Yeah.
any recourse?
If they want to claim potentially age discrimination, possibly in that
Yeah.
layoff was retaliatory in the sense that it was designed for them not to get their retirement. But age discrimination claims are very, very hard to prove. It is the hardest, if not one of the hardest, to prove of all the discrimination claims because employers often win because they can come up with some other non-age related reason for the action they took, and it's very hard to disprove that reason. So unless there's a smoking gun, like a text saying you're an old fart and you can't be here anymore, they're very hard to win.
Okay. And then Paula asks for fertility benefits.
Mhm.
She had heard that if it's a self-funded plan, it's exempt. Is that correct?
I believe it's currently exempt. I don't know that it's exempt forever.
Okay. And then Christine, another HR executive with us, uh, asks, is the education and training documentation required for employee file for education and training on the job or upon hire?
I'm not sure I understand the question.
Okay, Christine, you want to ask?
Yeah, so I'm curious, like upon hire, if people have certifications or
Oh,
their
yes, yes,
degree
yes.
versus like, for example, the mandatory sexual harassment training or the workplace violence prevention training or all of it. Does all of it need to go in the file or what's being referenced there?
Any training. Yeah, all of it.
Because, for example, one of the clients I work with, they keep a separate file, and this is how it's always been for their sexual harassment awareness training. So it's all the documents employees sign saying the training and the same for their workplace violence prevention. So I need to go in and put that in their actual employee file,
And you need
it
to
sounds
look
like.
at what, and going forward, you'll need to make sure that if you're doing it, your training certification or whatever you provide, it could be just a roster if you're doing a group, meets all the requirements of what has to be on that documentation. If it's a vendor that's doing it, to make sure that the vendor's providing a certificate that meets all the requirements. And I'm working with a couple of vendors now for a client who are scratching their heads saying, this may require us to reprogram our whole system. And so maybe we're going to not reclassify this as or classify this as a certificate and reclassify it as something else so we can get around this rule because we're not sure we want to comply with this, which then, of course, creates a cascading problem for the client, which is, well, I've got to provide the training, but my vendor doesn't want to provide it in a compliant way. So now I've got to find a new vendor that can do it, right?
Interesting. I didn't know that there was a specific kind of compliant form of proof.
I don't
So
think
I'll
they
have
care
to.
what it looks like as long as these elements are listed on it somewhere. Um,
Hmm.
so it's not terribly onerous, but it might require some reprogramming from the vendor to make sure their system can populate those fields, right?
Yeah, I think as I recall, like it includes what the training is, how long it was, the date, and the signature of the employee. So if it's anything beyond that,
Yeah.
yeah, it would.
It's not
Okay.
terrible, but it does have unintended consequences, right?
Okay. Interesting. Thank
Okay,
you.
and then Alan asks, if the company is California based, do these California laws apply to remote workers slash employees in other states? If you are the only remote employee.
Some do, some don't. So for arbitration comes to mind. California has looked at all of its statutes related to arbitration as being what we call in the legal world long arm statutes, which they're going to enforce in all 50 states. So there are some cases in other states where California employers have challenged this to say California has no, for example, authority to tell somebody in Massachusetts what they're going to do. And that's been met with mixed success. So some of these, yes, most of them probably not, but generally the state where the person lives or works, those laws govern. But some things, like I said, like arbitration, that California sees a long arm statute. And for arbitration, it's generally related to, I want to say it's labor code. Don't quote me on it, but I think it's 925 that basically says if you sign a non-compete in another state as a remote employee for a California company, that is unenforceable. It also says
Mm,
that if you move from a state where you signed one and now you're in California, like you moved here for whatever reason, and they're trying to enforce that non-compete, that is also not enforceable, even though you signed it in another state where it was. So there are some of these things that do have long arm statutes. And they're generally around non-compete arbitration and arbitration agreements. I'm sure there's more, but those are the two that come to mind.
okay. And there's another question. Is hostile work environment hard to prove?
Not particularly. I think the issue with people's perception of hostile work environment is that um, people don't recognize what a hostile work environment is from a legal standpoint. So legally, a hostile work environment is a work environment where you're being harassed or discriminated against based on some, or retaliated against based on some protected characteristic. So your gender, your race, your marital status, name it, health, disability, whatever. Your boss being a bully is not illegal. Your boss being mean to you, that's not a hostile work environment, unless it's derived from some action being taken because of a protected class. We employment lawyers get these calls all day long. Well, my boss is mean to me. That's hostile. Well, no, not really. So if they're hostile to you because of your race, that's different. But if, or something like that. But if they're just not a nice person, too bad. I'm not sure.
Yeah,
I'm not sure if that was the question, but it's not hard to prove as long as I mean, it's obviously easier to prove if there's text messages, emails, Slacks, whatever, um, because otherwise it turns into a he said, she said, or she says, she said, or whatever the case is, right? And then you've got to show how you're going to prove that. You've got
Oh,
to be able to
mhm.
prove it,
yeah, I
and you
asked a
have to have
question.
damages, right? So if you were constructively discharged essentially because it was so hostile based on one of those protected characteristics. Now you have damages. But if you're still in the environment, what are your damages? Well, I see a shrink 4 times a week because I'm so stressed out. Okay, maybe there's some little damages, but is it worth pursuing? Maybe you should just find a new job, right?
Okay. Another question to confirm. Education and training records must be in personnel file only, question mark.
No,
Having records and separate training outside does not meet the requirement.
I don't know that it's mutually exclusive. If they exist in the personnel file and you also have a separate file, I don't think that's a problem, but they've got to be in the personnel file at a minimum.
Okay. Okay. Evelyn, does that answer your question?
Yes, thank you. For most education and training records, they don't always exist in the file. And I think he just answered the question. You can have them elsewhere, but the
Sure.
requirement is in the personnel file. So, okay,
Right.
thank you.
Well, let me put it this way. If you got a request, like say an employee was coming after you and you got a request for the personnel file, which is common, right?
Hmm. Hmm.
If you could pull that certificate from your learning management system and include it in that responsive request for the personnel file, I think that would probably be sufficient because the reality is no one's going to go pull a personnel file on the spot and say, oh,
Okay.
is it in here? right? You have it.
Okay.
You can put it in the file if you need to. I mean, it exists in your LMS. I mean, if you have an electronic personnel file, I guess you could PDF the certificates, which actually is not a bad practice, and
Mm-hmm.
stick them in the electronic personnel file as well, but you'd have a copy in your MLS. I think that's fine, but they've
Okay.
got to be somewhere where they're accessible in the personnel file.
Okay. That makes sense. And that's helpful. Thank you.
Yep, of course. Thank you.
Okay, so someone else sent me a question and how to handle references and background checks legally and strategically, especially if they have confidential settlements or sensitive exits in their history.
Well, a background check is probably not going to find any confidential settlements because there's no way for them to find it. So, I mean, there's no court records or anything of it. There could be a case filed that you settled and then the case was dismissed. So that may show up in a background check because there was an actual case filed. I mean, if you're going for a federal security clearance, sure, these things are going to come up because they go far, far deeper. But if it's just a routine consumer background check that most companies are going to do without a security clearance, or you're not in a sworn position like a police officer, a firefighter, a child services worker, something like that, I don't know that anybody's going to find it. If the question is, well, I left my last job because it was a hostile work environment and I did a confidential settlement, and if I'm asked why I left, that should have been negotiated as part of your settlement about what you can and can't say. There's probably a non-disparagement clause, so you'll want to be cognizant of that. There's likely a confidentiality clause, so you want to be cognizant of that. And the answer is basically, it didn't work out. I really can't discuss it any further, or whatever you negotiated. If it was just simply a settlement agreement that was worked out and there was no lawsuit or administrative charge filed with the, say, for example, the EEOC or the CRD or the DLSE, I don't think a background check is likely to find it, unless, again, it's a deeper background check, like a security clearance or something.
Okay.
I'm not sure if that was
Another,
the question.
yeah, another question. If someone got laid off due to potential retaliation as a witness to a hostile work environment claim, what are the odds of winning a case via arbitration?
Well, you're going to have to prove that the layoff was retaliatory, and that it was retaliatory for being a witness in an investigation. So, assuming that you can prove that, and we don't know what the employer's position on it is. It's hard to say without knowing what the employer's take is. Um, I think the odds are probably fairly good, but it's always going to be facts specific. So this is a very general comment because I don't have enough facts to really answer it. What I will say is that in arbitration, you're going to be talking to either a retired judge or a lawyer, and you don't have an emotional jury there. So, from the perspective of damages, if you were to win, you're not going to have an emotional jury saying, "Oh my God, they really burned this person. Let's give them an extra $1 million or whatever." It's just not going to happen in arbitration unless it's really, really egregious, because the arbitrator or the lawyer who's acting as an arbitrator there's no emotion involved here, right? It's just very factual about everything. This is why employers like arbitration agreements, because they don't get what are called nuclear verdicts, because they're not going to get a nuclear verdict in arbitration unless something is very, very egregious, which is not usually the case. Employees like arbitration because the employer has to pay all the costs of it, except for the filing fee. I mean, they have to pay their own lawyer and they have to pay their own discovery and everything, but they don't have to pay for the arbitration itself, other than what would have cost to file a lawsuit, so $400 or $500. But arbitration fees, I mean, I got one a couple of weeks ago where the arbitrator, for basically a couple of days of arbitration, wants north of $115,000.
Wow.
So, so that's an incentive for the employer to settle, obviously, right? Which is what we're probably going to do. But the employees don't like arbitration agreements, on the other hand, because they don't get that emotional jury. The other reality here is that 95+% of employment cases settle before arbitration or trial. So the chances of actually going to arbitration or to a trial are very low.
Okay. Well, we are out of time. Michael, what's the best way for people to get in contact with you? John had mentioned that the link said something about it's not a private connection. What's the most effective?
What link said it's not a private?
I don't know, John.
The link to your website, if we Google you or we
Mhm.
in your website, it comes up, it's not a private connection.
Really? Thank you for telling me. That shouldn't be happening because it absolutely is a private connection with all kinds of
Yeah.
security on it. So I'll have to check into that. Thank you.
Yeah, something's
Okay,
not
and
working. Something's not working.
Okay.
but
Thank you.
reach out to Michael and we'll make sure that we have Michael's information when we send out the recording. And Michael is so generous with his time and his information, and he's a great resource for you, whether you're with a company or as an individual. Michael is just by far one of the hardest working employment attorneys that I've ever met. And so Michael, thank you so much for being with
Thank you.
us. Really, really appreciate it. We're going to have you up on our YouTube library before the end of the day, and we'll send you the link that you could use as well, Michael. Thank you so much.
Thank you.
And
Can I just conclude by saying again,
yes,
no legal advice, just information only, all that good stuff.
you got it. You got all the disclaimers.
Yeah.
And so for all of you, we have another speaker next week that's going to be talking about mining your LinkedIn connections and best practices for messaging. And it will not be recorded. She is not allowing this session to be recorded. So if you want to be with us next Friday, we'd love to see you. And Michael, thank you from the bottom of my heart. You know how appreciative I am
Thank you
of
for
what
having
you
me.
do. And so thank you, everyone. It's great to see you, and enjoy the weekend. Be safe and stay warm if you're in a cold place. Stay cool if you're in Southern California. We're going to be over 80 today. Thank you, everyone. Bye.